Thank you all. I'm proud to be here. In this group are a lot of my clients in this litigation, and so it's an honor to appear before you and give you an update about what's going on in this important litigation. It's nice to follow the state police because you get a history of and a little bit of identification of the problem that all the communities are facing. And I probably don't need to spend a whole lot of time explaining what the problems are. But the one thing that it appears to me, listening to discussions about the problems and discussions about the solutions, is all of these are going to cost a whole lot of money. And this is a problem that we're in as communities, and we're not in it because of anything we did as communities wrong. We're in it because of systematic failures caused by the actions of some of the largest companies in this country who've done a lot to cause damage to us in our communities. And the reason we've now brought these lawsuits is because we believe that they need to be part of the solution. And the way they need to be part of the solution is to help us pay for all of these expensive treatments and other options and pay us back for all the money we've spent on this. So, I want to start with an anecdote about why I'm in this litigation. I have a really good friend who's one of my neighbors, and is a lawyer in Charleston, West Virginia. And West Virginia and Eastern Kentucky and Southwest Ohio, sort of we call the epicenter of this problem, where it all started. And in my community, my friend had a daughter, an adult daughter, about the same age as my daughter, and she ended up having addiction problems. And but she had a father who had the wherewithal and the good sense to get her treatment and got her off these drugs. And she's away at school in Michigan. As a runner, had some running injuries and ended up having to have some pretty minor outpatient surgery. And so all over her charts are, and this is a recovering addict, all over her charts are, do not prescribe opioids. And of course, what happens is she gets discharged with an opioid prescription, fills the prescription. It is so hard to kick this habit, and she felt temptation and overdosed. And that was such a sad incident, and to me, it was illustrative of this is not a problem of, people think about drug addicts sticking needles in their arms, and that people don't start doing that. Where they start and where this problem started was our pharmaceutical manufacturers and distributors who hooked our populations on these drugs. And I'm going to tell you a little bit about that story and what we are doing in the litigation to try to make things better. Get the slides up. Okay, go ahead. Let's see. I guess I have that. This is old data, and this is probably not anything that any of you don't know. But every 25 minutes, a baby is born suffering from opioid withdrawal, and that to me is illustrative of. It's not just a problem on the addicts, and we can talk about whether or not they're to blame, but we are now creating a generation of children who have problems through really no fault of their own. The numbers of the opioid epidemic are staggering, and we don't have the 2018 data yet, and I'm not going to read through them. You all can read them, but 130 people died every day from opioid abuse, and these are nationwide numbers. And what's really sad for me and you all is in our communities, in the epicenter, the numbers are even higher in terms of our populations because it hit here first and hit here harder. And so these are nationwide. These numbers are nationwide numbers, but on a per capita basis, we have an even bigger problem. And then here we have deaths as they're ramping up through the years. And what I want to talk a little bit more about is the costs. And these are nationwide numbers, but we're projecting by 2020, we are going to have almost $200 billion in expenses from this epidemic. So it's not something that any one of our communities, we don't budget for this. We don't have the tax base to solve these problems. If we're going to get out of this mess, we're going to have to get help from some people, other people, and I think what we need to do is get help from the people who help cause the problem. little bit about what we're doing. I'm part of a consortium of 6 law firms. In our 6 law firms, we represent, with local lawyers in Kentucky, 50 counties and 2/3 of the population of Kentucky. Nationwide, in the national litigation, which I'm going to talk about, we represent approximately 600 cities and counties in one state, and which runs about 20% of the population of the country. Now, the cases we filed all in federal court, and the federal courts have transferred those cases and consolidated them in front of a judge in Cleveland, Ohio, and I'll talk a little bit more about that in a minute. But that's where all your cases are right now, and we believe that's a good thing, and there are several reasons. The state has also brought some lawsuits by the Attorney General, and those 4 separate cases, they are pending here in state court in Kentucky. There are 2 groups of defendants in these lawsuits. The first are the manufacturers, and listed Purdue, Endo, Janssen, Teva, Allergan. These are companies that manufacture the opioid products, and Purdue Pharma is probably the #1 cause, in my opinion, of this problem. They are the manufacturer and creator of the drug called OxyContin. And what they did when they created OxyContin is they seized, and the theory of liability is against them is false and misleading advertising. What they did is they seized upon some questionable science and went out to convince all of the doctors in our communities that if you really weren't an addict and if you really were in pain, the danger of addiction was very low. And they started citing this, quote, article. It was actually a 1980 letter to the editor in the New England Journal of Medicine, and essentially these 2 doctors wrote and said, we looked at 11,000 patients, and there were only 4 cases where we had addiction problems. We really don't think it's a problem to prescribe narcotic drugs in hospitals to people who have no history of abuse. So we're talking about people who are having surgery, short-term, those sorts of things. So what the opioid manufacturing industry did, took this and some other studies, and went out and did direct-to-physician marketing. I first became involved in this litigation in the first round in the early 2000s when Purdue Pharma was the defendant. And the reports we would get back from their salespeople, we had one doctor who complained to Purdue Pharma executives because a drug representative came to him and told him it would be medical malpractice not to prescribe OxyContin, opioid OxyContin, for menstrual pain. Those are the kinds of things they were telling the doctors. As a result, opioid, and at about the same time, pain became what was called the 5th vital sign. And the idea we were going to judge hospitals and doctors based on whether or not their patients are in pain. So if you make something a criteria and then you provide an easy way to solve that problem, cheap opioid pain medicines, then that's what's going to happen. So it's really not a surprise when you look back on it. We are in the problem we're having. Now, the second group of defendants are the distributors. They are McKesson Company, Cardinal Health Company, and AmerisourceBergen. And those little numbers under their names, 3, 15, and 11, those aren't in the medical industry or the pharmaceutical industry. That's their rank in the size of the largest corporations in America. So we have the number 3, number 15, and number 11 largest companies in America who are the ones who distribute these drugs. And their role, they sit in between the manufacturers that we just talked about and the pharmacies and other companies that actually provide the drugs to the end users. And they have particular position under the law and particular responsibilities which they have totally abdicated, which is part of the reason we are in the process we're in. And that is they have a duty under federal law to report suspicious orders, and in state law most places. And absent that, the Drug Enforcement Administration and your state pharmaceutical boards have an obligation to police those. But absent the information about suspicious orders, there was no reason for them to know who to go after and what to go after them for. essentially, the duty on the distributors is know your customer. And here's a picture of, and I'm not sure where this one is. It's a pain clinic. I'm not sure if it's in Eastern Kentucky or Southern West Virginia, but essentially we have lines out the door. We had pharmacies in some of the places in Southern West Virginia that distributed millions and millions and millions of pills every year with populations of less than 100 people. So the distributors in this system have this obligation, and we'll go down here. The distributors and the manufacturers have an obligation, if they know or should know of an order that's suspicious, they need to either investigate and figure out why it's not a problem, or they need to not ship the order. And they need to report that to the DEA. What the distributors were doing in this case, where they were ignoring all of those obligations. So they were shipping these millions and millions of pills to small pharmacies in Kermit, West Virginia, and in Eastern Kentucky. They were doing that. Their own internal checks would pop up and hit the stop sign, the warning sign, and they'd override those and continue to ship. Why? Because this was a very profitable business for them to be in, and they made a lot of money doing it. So we brought the lawsuits, and in essence, one of the questions that I get asked by my clients in this is, what is it possible for us to recover in these lawsuits? And these are the lawsuits we're bringing on behalf of local governments. First thing we're looking for are past damages. I'm sure all of your budgets have ballooned with respect to dealing with the problems caused by the opioid problem. It had police, first responders, Narcan expenses, substance abuse programs, treatment. Even in my area, we've had our funds for indigent burial completely exhausted months into the year, and having to have them replenished just to deal with the problems caused by the opioid problem. But we're never going to. We have a whole bunch of people now who are addicted, and we're never going to get to the end of this problem unless we do something about those. And so they're future costs, and those are also the damages we're seeking in this litigation for education and prevention, for law enforcement, to fund the people that need to end up in jail. And I agree with the Commissioner of State Police that that is not something we want to do as our first option. But when we do have to put people in jail, somebody's got to pay for it. And then, most importantly, addiction recovery and treatment, because that's the only way we're going to get ourselves out of this situation. And again, all of that costs money. Litigation. And as I explained, the majority of the cases brought by cities and counties were filed in federal court or removed to federal court by the defendants, and then under transfer rules in our federal court system, they were consolidated and sent to multi-district litigation. The purpose of multi-district litigation is to apply economies of scale and have consistent rulings and in terms of the litigation. And so what the courts say, if we have thousands of cases that are bringing the same claim, rather than have hundreds of different judges looking at them and having to make these rulings, we'll send them to one judge and have him manage the process. This particular case, the MDL was formed in December of 2017. The picture there is Judge Polster, who is the federal district judge in Cleveland, who is in charge of it. He has experience doing other multi-district litigation, and he's taken a very active role in this case. The first thing the judge did is he had a case management conference and set forth his idea of how the litigation was going to run, and appointed leadership among the lawyers on both sides to help manage the litigation. Our consortium has leadership positions. Every one of the 6 firms has members in those leadership positions, including one of the members of our consortium, Paul Farrell, is co-lead counsel. Peter Muset I think a lot of you have met here, is in charge of the distributor case. I'm on the chair of the Law and Briefing Committee. We have a big role in this national litigation. All told, our group has probably half the cases in this national litigation. The court ordered settlement talks at the beginning, and bless the judge, he thought maybe that he would be able to talk these defendants into doing the right thing. And we're not allowed to talk about the specifics, but I will just say that where we are now, we have not made progress to the point where we've actually reached any settlements in this multi-district litigation. Instead, what the judge has been convinced is that in order to remove the roadblocks to resolution of these cases, we're going to have to litigate them some first. And so that's what we've been doing over the past almost year now. And what does this mean? We've been doing discovery, and we've been asking them questions, doing depositions of their employees, and they've been producing millions and millions of pages of documents that we're reviewing. And what's the end goal of that? And that's the judge has set some cases as what we call bellwether cases. And so the parties don't have differing opinion on what these cases are worth. So the theory is you pick 2 or 3 cases that somebody thinks might be representative of the group, and you set them for a trial. And in this case, because the judge is in Cleveland, he picked 3 Ohio cases. The case involving the city of Cleveland, the case involving Cuyahoga County, which is the county surrounding Cleveland, and the case involving Summit County and Akron, which is a little bit next door. They have problems just like our communities. They're a little behind where we are, but they're still typical of the cases across the country. And over the past year, we have been doing discovery in those cases, producing documents from those cities and counties of our damages and our liability, working up expert reports, and doing discovery into the liability cases for the defendants. Currently, we have a bellwether trial set for next September. When we get a little bit further on, I'll give you a little bit about the scheduling of that. But that's the idea. And here's sort of a summary: 70 million pages of documents have been produced by the defendants. Again, this shows you the advantage of consolidating these cases. There really isn't any way you could litigate these cases one at a time and be able to go through 70 million pages of documents. The plaintiffs in these 3 cases have produced 1.6 million documents of their own. You guys are lucky. While we're going to ask you to produce some information about your communities and fact sheets, it's nothing like these that Cleveland, Cuyahoga, and Summit and Akron have been having to produce. The next step is those fact sheets. You all should have had contact with some of the members of our team or your local Kentucky lawyers that are working with us on those. And the judge has entered an order that all cases that were transferred to the MDL before September of this year must complete and file those fact sheets with the court by December 17, 2018. If you've got any questions about that, we want to help you get those done, and the courts has indicated that he's very serious. We're not making you produce 1.6 million pages of documents, but the limited information that's in those fact sheets is very important. And the reason is the judge still has the idea that he's going to try to settle this case nationwide without making us try hundreds and hundreds of the cases. And to do that, the defendants need to know about you and all of your claims, and that's the point of the fact sheets. It's an easy way for us to get that information to them. We're also doing depositions. We've so far have taken 25 depositions of the defendants' representatives. We have mostly been focusing on the distributors, and that would include the pharmacies. McKesson, Cardinal, and AmerisourceBergen are the 3 big distributors I told you about. Walgreens is another. As the pharmacies, Walgreens, Walmart, Rite Aid, they also are distributors. They own their own distributors, so they share a big role in this problem. And we've been working on depositions in their cases. Another thing that's happened over the past year is we have gotten production of the ARCOS Database. What's the ARCOS Database? And people in this litigation talk a lot about that. The ARCOS Database is a confidential database from the federal DEA, which has reports of every shipment of opioid pain medicine, from the manufacturers to the distributors, from the distributors to the pharmacies. And it is basically a master pill tracker. It's important because it lets us figure out market share. It also lets us figure out the activities, where these pills were being shipped, and we can also show the violation. So in that pharmacy in Kermit, West Virginia that got millions of pills, there are transactions reported in the ARCOS database, and that's how we know what each of these pharmacies received. And we can make our arguments for why these distributors should have stopped those orders that were not for legitimate medical purposes, just from the size, quantity, frequency, those factors alone in the ARCOS database let us prove liability on the part of those distributors. We had to fight the DEA to get it, fight the defendants to get it. The DEA initially opposed that, but later changed their position and cooperated with us, and we're now in a position where we have gotten that ARCOS data. Over the summer, as part of the bellwether tracks, Judge Polster, at the request of the defendants, the defendants told us that they believed that they had legal defenses to our claims, that we weren't legally entitled to recover for our damages. And so we agreed with them and the court to tee those up to consider motions to dismiss. The first round of that, we briefed 8 different jurisdictions, including one of the tribes and including some cases brought by hospitals in addition to cases brought by cities and counties. The first one of those motions was Summit County, City of Akron, was picked as to one of the motion bellwethers. And a few weeks ago, we got a ruling from the special master who had been charged for the initial ruling. It's a 100-page ruling, which we won almost everything, and we're very pleased with that. He recommended that the bulk of our claims not be dismissed, including our federal racketeering charges, which is a very big deal because those charges, if we succeed on them, bring us punitive damages in the form of treble damages and a fee-shifting attorney fees would require them to pay our attorney fee expenses. Some of the common law nuisance claims were recommended to be dismissed based on a peculiar Ohio statute. We don't think that's a ruling that translates elsewhere, and we're challenging that ruling. We filed our objections to that recommendation. The defendants filed 45 pages of objections to the rest of the 100-page recommendation. The court allowed us 10 pages to reply to their 45 pages of objections, which leads us to believe that we don't think he is going to be finding many of those objections to be good ones. The other thing the defendants did is they asked that now having lost these issues, asked that they be sent to the Ohio Supreme Court for the Ohio Supreme Court's view on those rulings, and the judge denied that, which is good because that would have caused us about a year delay. Judge Polster's, or the magistrate's ruling, and what we expect Judge Polster to do with it, are consistent with what's been happening in other courts. Overwhelmingly, the defendants are losing these motions, including recently a ruling that the AG got in Franklin County. So in addition to that, we have Alaska, the Suffolk County, New York opinion, Ohio, Oklahoma, New Hampshire, New York, a bunch of New York rulings that have been favorable. State of Washington in Washington State Court, Tennessee, Missouri. There was a Washington case that was pending in federal court before the transfer. There was a good ruling out of that case. There was also a good ruling from the city of Chicago in their case before the transfer. And then the 2 West Virginia State Court opinions that predated most of this current litigation. These 2 cases were some of the cases that first got this litigation started because the Attorney General of West Virginia was the first one to get some of the ARCOS data to disclose it. Couple of things that are coming up. The court, now that we have the ARCOS data, we know who distributed and who sold what pills in all of your communities. The court has recently just authorized us to look at that data for all of your communities and then look and make sure that we have included all the defendants. We will probably be adding defendants to all of your cases. We have till March 16th to do that, but it's a complicated process. So, and I'm in charge of that. So you're going to be getting communications from me and my office. At some point, you're going to start getting drafts of proposed amended complaints, and in those are going to be suggestions that we have you add new defendants. Possibly we might take some away if the ARCOS data doesn't support our initial conclusions. But what the court has said is it has given us access to data that would show every manufacturer that provided more than 5% of the market share in the county in at least 3 of the last 9 years, and the same for the distributors. And then with pharmacies, we're going to get to see all opioid shipments to each pharmacy in all of your counties. We are proposing to the court that they allow us to file a short form amended complaint. It will be a 2 or 3 page document, which will give you a whole lot less to review. But when we send those to you, I'd ask that you, we're probably going to send them with a, here it is, this is our proposal. We're going to file these in 2 weeks unless you have any concerns in that way. We have, in terms of the consortium, we have 550 of these to get through. So, and we believe that none of you are going to have problems, but we welcome your input. And if in this process now, any of you all think that you want to be involved on a more granular level as to the details of who we're going to add, I encourage you to contact me or any of the other lawyers that are working on this case, and we'll get with you and get you. You'll have to sign off on the protective order that lets you access the ARCOS data, but we'll be happy to do that if you're inclined to do that. This is the trial schedule. The trial scheduled, the first trial in the Cleveland, Cuyahoga, Akron, Summit County is set for September 9th. The deadlines are coming up fast and furious. We're working our way. We think we're on schedule. The defendants are doing what they usually do and try to delay and drag their feet. We're holding their feet to their fire. The magistrates and special masters that Judge Polster has appointed to help him in this case are not showing any sympathy for the defendants for their excuses for not doing what they need to do to comply with these orders. And on the other hand, they're pushing us as hard as we're pushing them. I've shown you before, we have 1.6 million pages of documents from those cities and counties have been produced. So that's what we are. And I'll stick around outside for a little bit if anybody has any specific questions. That's my contact information up there. And again, I'd be happy to talk to you and close with thanking you for allowing me and the rest of the members of my firm and my consortium the honor of representing you all in this very important litigation.